Hello and welcome to the Daily Synopsis by Bar and Bench, where we give you a brief summary of the most important legal news of the day. Chief Justice of India NV Ramana remarked on Monday in an open court that public interest litigations were taking up the court's time and attention, which could have otherwise been devoted to hearing real matters. The CJI made this observation during the mentioning of an environmental law case. Meanwhile, the Supreme Court also issued notice to the central and state governments in a PIL to enforce fundamental duties under Article 51A. The plea sought directions to the centre and states to make comprehensive laws in order to ensure adherence to Article 51A of the Constitution. The Supreme Court on Monday said that the petition filed by school students against holding of board exams for classes 10th and 12th via offline or physical modes shall be listed before a bench led by Justice AM Khanwilkar. The plea filed by students from over 15 states across the country was mentioned before Chief Justice of India NV Ramana by Advocate Prashant Padmanabhan. The petitioners highlighted the difficulties and pressures faced by the students owing to the interruptions in their schooling due to the COVID-19 pandemic. The petitioners have sought an alternative assessment method for the upcoming exams of classes 10th and 12th instead of holding physical board exams as proposed by the state boards like CBSE and ICSE. Former Supreme Court Judge Justice Madan Lokur lamented the reaction of the executive and the courts in India to hate speech, particularly by ministers, this Sunday. We've had in Delhi a minister saying Goli Maaro. What is that if not incitement to kill? The former judge said. Justice Lokur was addressing a talk organized by Manthan Life to address hate speech in general and how Indian courts have been dealing with it. He called upon the parliament to enact a law on hate speech and for courts to be far more proactive while dealing with such cases. The Delhi High Court today reserved its judgment on a batch of petitions demanding the criminalisation of marital rape. During the hearing, the central government told the court that it cannot take any stand on the issue of criminalisation of marital rape without first consulting with all the stakeholders, including the state governments. SG Tushar Mehta said that a communication had been sent to all the state governments asking for the suggestions most immediately. Justice Rajiv Shakdhar pulled up the centre for not making its stand clear. He said that a decisive executive had to say yes or no and could change its stand at a later point of time. However, SG Mehta reiterated that the centre's only stand was that the matter should be deferred, refusing to do so, and after noting that all the other parties had made their arguments, the court reserved its verdict. In today's hearing in the Hijab Ban case before the Karnataka High Court, Advocate General Prabhuling Nawadgi said that the petitioners were claiming that the hijab was an essential religious practice with a view to bind every Muslim woman to a particular dress code. The AG further told the court that the 2018 Sabrimala verdict of the Supreme Court, which laid down how to determine the essentiality of a religious practice, was currently the law of the land on this issue. The central government had filed review petitions against the Sabrimala judgment, which are still pending before the Supreme Court. He also contended that the petitioners had not placed any material on record to substantiate their claim for the declaration that hijab is an essential religious practice. Justice J.M. Kazi, the only female Muslim judge on the panel, spoke for the first time today, asking if essential religious practice was applicable to the freedom of conscience as well. The three-judge bench will assemble tomorrow at 2:30 p.m. to hear the matter again.
Subscribe to our YouTube channel and click the bell icon.